Welcome to today's meeting of the Transportation Licensing Commission. If you'll please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. We're now in the public comment period of our agenda, and there have been no requests to speak. Pursuant to Tennessee Public Chapter number 300, we've been reserving time for public comment on matters related to items appearing on the agenda today for today's meeting, and we've been allowing up to 8 individuals to speak for an allotment of 2 minutes each, and there's been no requests for today. Prior to the meeting, Mr. Rooker circulated the draft minutes from last month's meeting. Have the commissioners had an opportunity to review those minutes?
Councilwoman would like to speak during the public comment period.
Sure.
Sorry.
Okay. Good afternoon, Commissioners. Sorry, I didn't know I needed to sign up. I appreciate the opportunity to speak with you today. So I'm here to speak on the booting legislation that came before you last time, your last meeting. It is on your agenda today. Last meeting I wasn't able to be here due to another commission that I had to be at that day. So some of the material that was covered in that meeting was specific to the Englewood Post Office, which is in District 7, which I represent. And so I wanted to just give you a quick background on that. The parking where patrons of that post office have parked for years is marked as private parking, not, in my opinion, to the standards that are required under the current law. And it's in cursive writing, it's not in big writing, but what happened is that a booting company parked a pickup truck with a bed full of boots and began, as soon as people pulled up, began to boot the vehicles that were there immediately without a grace period. And so the legislation that came before you last time, I believe today you're going to, I hope, defer it, and I'll explain that in just a second. That was certainly a cause of great concern for people in the area in Englewood and in District 7 in particular. So that predatory behavior is something that I hope that we're able to overcome and prevent from happening in the future. I certainly understand the need for parking enforcement to take place, but that was particularly predatory in my opinion. The legislation that is before you, the state actually has legislation that they're working on that's in committee currently. They're scheduled to end their session any day now, potentially this week yet, but more likely, well, we'll see when they're, but that legislation, should it pass, has a lot of the information that's in the bill or the draft that you received, with a couple of exceptions. And so 2 exceptions that were in our legislation, or the department's legislation, is the grace period, as well as some background information. I believe legal can explain that later. But anyway, I do hope that at some point when the state passes theirs, should they pass it, that we are able to tighten up those couple of clauses that would make it even more restrictive in Davidson County, which I believe the state will allow. So with that, thank you for your service. I appreciate you. And I know this is volunteer service, and so I know sometimes your meetings run long. So with that, I'll go ahead and let you move on to your business. Thank you.
Thank you very much.
Mr. Chair, you were going to speak as well. I wasn't aware we had signed up in advance here.
That's fine, Mr. Winters.
Most of you know me, but Michael Winters, Nashville Tractor, and also cruise in Nashville. I'll keep this comment brief, but it's about an agenda item that I got a funny feeling we may not get to, so I just wanted to throw this out there. Mr. Billy Fields is here today to be celebrated for all of his hard work he's done. For those of you that don't know where he lives, he's hours away from here, so it's not a convenient trip for him to come down here. One of the agenda items that we may not get to that very well may be postponed to the next agenda meeting is whether or not he authorized the special route for Old Time Trolley. I'm hoping the commission would allow him to speak and be on record on whether he did or not, seeing how it's not convenient for him to probably come back in May if it gets pushed. I just wanted the commission to think about that, and if you think you're going to push the agenda, to let Mr. Fields speak so that he doesn't have to come back in May and travel hours back and forth to get here. That's my only 2 cents.
Thank you.
Mr. Chair, if I may as well.
All right.
Thanks so much.
Alrighty, hello everybody. Patrick Kludak with Upstage Party Bus. I just wanted to speak on account of the fact that we're not able to have a liquor permit. You can't obtain one with the state, so therefore all of our groups that prefer to drink something like High Noon, which is a 4% drink compared to a White Claw, which is 5%. They're allowed to drink White Claw, however, they're not allowed to bring on High Noon. This is a major problem that I'm having due to the fact that I have many people canceling with me and booking with another company that is allowing it. I've been told you can, I've been told, quote unquote, that we're not looking at it. I'm still not going to allow my guests to bring White Claw or High Noons on board due to the fact that it is your guys' rule, and you guys are the only ones who can change that at the current moment. From what I'm understanding, I'm sorry, legal, I'm not 100% sure on this, but clearly there's no way that we're allowed to have it. And when it comes down to permitting time, I'm following all the rules, regulations that you guys put into place because I respect those rules and regulations. But losing my guests to another company that allows it is basically a slap in the face because there's no way for me to go ahead and get that permit to allow that. I'm not trying to have hard alcohol on board. I'm not trying to have anything over 8% on board. I'm just trying to have drinks that are canned and labeled as 4%, so that way my guests are happy because it's a different option for gluten-free, allergies, and all that other type of stuff. You can't have something that's a malt beverage if you're gluten-free. It's just, that's the only options that they have as far as hard alcohol. So if we could take that into consideration today, I would greatly appreciate it because I keep on losing money left and right on account of these people canceling their reservations with me and switching. So appreciate your time. Thank you so much.
That is not an item on our agenda today, but it is something that I think we could put on a future meeting so we have everyone have notice of the issue. But Teresa, you look like you need to add something.
Regulation of liquor and alcohol is solely the province of the state. It's state legislation, so you don't have any jurisdiction to regulate alcohol other than beer. And that's
So-
the province of the beer board.
So what ordinances are you referencing?
I've been told by reaching out to MTLC that I'm still under your guys' rule not allowed to have it on board. So I'm not having it on board. It says it across my website, and I'm losing out on reservations, and it's literally a knife in my side that's just bleeding out, and I keep on being the only company that's bleeding out because if I don't obtain my permits for next month, then I can't feed my family. I can't put a roof over my head. So therefore, excuse me for being flustered with this, but I'm a little stressed out about the whole entire thing, and I would just like clarification on if I can in fact go ahead and have that on board due to the fact that it is in fact a drink that's under 8%.
Well, all I can say is I would highly recommend that you consult with legal counsel and find out what you can and can't do, because we can't, as a commission, tell you what you can and can't do. But I would highly recommend you retain legal counsel and get some legal advice on the point.
May I ask y'all, if I were to have it on board due to the fact that you guys aren't ticketing for it anyhow, if somebody were to take a picture of my bus and say, hey, that guy is drinking a high noon at this time, this timestamp, would that be penalized in the permits that y'all are considering?
You need to retain legal counsel and get legal advice on what you can and can't do under the law, because we are not in the business of giving legal advice. We're in the business
I understand
of
that. I understand
running
that,
the commission.
but I'm just following y'all's rules that you put into place. That's it. And since the rule, the wording was changed by this legislation, then because of that, I need to follow it. And I'm going to follow it. It just stinks because I'm losing out on a lot of money. The same way that I'm losing out on a lot of money for 4 to 6, when other companies are running with no violations. I will stop. I'm not running between 4 and 6 because of those violations. Another thing I should contact legal about, or?
Well, when I say contact legal, I mean your own private
Sure, yeah.
attorney. Yes, I would consult with an attorney to find out what your legal rights are.
Okay, all righty, thank you.
Have the commissioners had an opportunity to review last month's draft minutes? Is there a motion regarding approval or amendment?
Second.
All those in favor of approving the draft minutes?
Aye.
Motion passes. The next item on the agenda is quite a pleasure. As many of you know, Director Billy Fields recently retired, and Richard Rooker is our interim director, and we wanted to have a time to kind of recognize the service, the long service that Mr. Fields had with the TLC. And Mr. Fields, as Mr. Winters pointed out, does live quite a ways from here, so we're very happy that he's driven in today to be with us. We wanted to present to him, a small token of our appreciation. But before I did that, I wanted to kind of read off some of his history. Oh, yeah. So, Billy, hi. So nice to meet you. This is my wife, Donna Fields. So nice to meet you. So Billy, I'm going to read from my notes because I don't want to miss anything here. Billy is a native of Goodlettsville, Tennessee, where he spent many years in his early life working in his mother's dry cleaning business. Went to Goodlettsville High School, attended Volunteer State Community College, got his bachelor's degree from Austin Peay, and then got a master's degree from Western Kentucky. And he's been with Metro government for many, many years. In 1998, he was special assistant to Mayor Bill Boner, and since then he's served every mayor that we've had since then. Throughout his career, he served with the codes and building safety, the juvenile court, public works, transportation, and multimodal infrastructure, as you all know. Billy managed the disaster relief for Metro after the 1998 F3 tornado that came through downtown and East Nashville. And he also oversaw a lot of disaster relief during the floods in 2010. He served 2 stints as our transportation licensing director. He served a cumulative amount of 15 years as our director. He's a co-founder and chair and emeritus of Neighbor to Neighbor, and he was honored with the Lifetime Achievement Award in May of 2022 for his many contributions as a volunteer and community leader with that organization. He continues to be a community volunteer with the YMCA, the Boy Scouts, Community Foundation, as well as lots of other civic groups, including the American Cancer Society, Rebuild Together Nashville, and he's alumnus as well of Leadership Nashville. So I really wanted to take a special moment to recognize, his years of service. He's retired now. Billy, please accept this small token from the commission. We had you know, I want you to open it. It's a surprise. It's,
You know what I always heard about Mr. Fields when I got appointed to this commission was that if you wanted to know where the skeletons were in that old courthouse over there across the street, he was the guy to talk to. Now that you started during the Boner administration, I suspect there's some real juicy ones over there. Mr. Fields, I'd like to, on behalf of this commission and the commissioners and all the previous ones that you served so diligently with, we want to present you with this token of our appreciation. Would everybody please join me in applause for Mr. Fields?
Point of personal privilege, Mr. Chairman.
of course.
Be the last time I get to ask. You know, when I went to work for Mayor Bowman, we came in at the courthouse, we went through a very brutal election. We actually was in a runoff with one day Mayor Bredesen, who ended up being governor. But that night we walked in the courthouse, he sat in his chair, he said, "Now, Billy, there's two things you need to know. The most popular day I'm going to have is right now. The second most popular day I'm going to have is the day I leave." And they'll enjoy when I leave more. So I got to admit, I've been pretty popular since Groundhog Day when I retired. I want to thank each of the commissioners. I've said many times on the record, and I'll continue to say on the record, the most thoughtful, caring, hard-working commission in this government. I have served under Mayor Boner and Mayor Bredesen and Mayor Purcell and Mayor Dean, Mayor Barry, Mayor Briley, Mayor Cooper, and a little bit under Mayor O'Connell. But in some of those administrations, I was the guy who sat in the office trying to get people to serve in these roles. They're unselfish. It's hard to get people that want to spend the time they spend. You are the ones that should be honored for the hard work that you do, for the care that you have. You know, your lawyers work hard every day. Your Channel 3 staff, I'm not even going to talk about them. I look over at your staff, Mr. Rooker, and TD, and Lisa, and the ladies back, and NDOT that adopted us a few years ago when we were still Public Works. I'm appreciative of all of it. I appreciate it. I would say I'm most appreciative, and I brought her up, my CEO, who has I'm going to tell one quick story and I'm going to get out of here. She has a little greenhouse up on that mountain in Wilder, Tennessee, which is up on the other side of Cookville. Last year, she produced about 2,000 pounds of food, a little over 2,000 pounds of food that all goes to Meals on Wheels. She doesn't let me eat the tomatoes. So she works hard, and I've got a feeling there's some tilling I'm going to be doing when I get back this afternoon. So I can keep talking. I'm not. You know I can talk. Good luck, Mr. Rooker.
Thank you.
I leave y'all in capable hands. And if it's all the same, I would come back next month. It is a little bit of a drive, but that way it won't confuse anything that may or may not need to happen in today's meeting. So I'll just take my crystal and I'll go to my. I would say one last thing. For many of you that I've been your regulator, I know there have been days where you weren't happy with me, but know that it was never a personal thing. We always wanted to be fair and open and treat each of you exactly the same on everything that we did. And that's the way I'm confident it'll continue, and I wish you all good luck, and I appreciate everything that y'all have let me do. Thank you.
Thank you.
All right, first substantive item that we have on our agenda today is under booting services. Last month, we began reviewing an ordinance to amend Chapter 6.81 of the Metro Code regarding booting services following the public hearing held, noting proposed changes to SB 1692, HB 1731, that has been happening since that March 2024 meeting. So, Mr. Rooker, I know staff had a recommendation for us with regard to this item.
Yes, Mr. Chair. Until this legislation is, as long as it's still pending, it's still at the state, we would recommend deferring booting services until such time as we understand and see what actually says.
Would anyone like to make a motion regarding deferral to, is it next month, or do you think we'll need more time?
They'll be out of session this month, so next, we can move it to May, that we should be good there.
So,
Unless,
should move it to June.
you want to move it to June? Yeah,
Just because we have the public hearing next month.
that's true. May's gonna be busy, so if
Yes.
we can defer to June, that'd be preferable.
Mr. Chair, presumably, we don't want to act on a proposed ordinance until we understand what the state's going to do.
That's right.
If that's the case, then I would make a motion that we defer this agenda item to June.
All those in favor? Aye. Any opposed? Motion passes. Next item on the agenda is a request for reconsideration from Mr. Knapp, which was also deferred from March 2024. Mr. Knapp.
Hello, everybody. I'm the Metropolitan Transportation and Licensing Commission. I'm just going to start this request for reconsideration. This is regarding the sanction imposed by this body on Nashville Booting LLC. As you recall, the complaint was filed against Nashville Booting LLC as well as Mr. Fields, and I dismissed the complaint against Mr. Fields because after the disciplinary hearing, it felt that there was a legal question that needed to be resolved about what exactly the director's authority is. So for the benefit of the public in the room, I will read this request for reconsideration, and then we will touch on to last meeting's comments about it. Chairman Hernandez, I write to thank the MTLC commissioners for their leadership in fairly and meaningfully hearing the complaint against Nashville Booting LLC on February 15, 2024. I also write to correct the Metropolitan Department of Law's incorrect interpretations of Chapter 6.81 of the Code of the Metropolitan Government of Nashville and Davidson County, with respect to whether the MTLC Executive Director has the unilateral authority to issue a booting license without public hearing before the full MTLC. For the reasons below, no such unilateral authority exists for the MTLC Executive Director, and I urge the MTLC to officially adopt and codify at its next regular meeting the legal interpretations set forth in this letter to prevent further confusion, harm, and inconvenience to the public. Section 1. Metro Legal's interpretation of the Metro Code is inaccurate. On February 15, 2024, Metro Attorney Therese DeCostanis was asked by Commissioner Carr, quote, does the MTLC Executive Director have the ability, without this body, to issue a booting license if one is not already in place? Ms. Costanis replied, quote, he does, and then stated her reliance on Section 6.81.020D of the Code, which states, application approval and disapproval. Upon disapproval of the license application by the MTLC Director, the applicant may file an appeal with the MTLC within 30 days of denial and request an appearance before the MTLC. The appeal shall be heard by the MTLC at the next available commission meeting, with the appellant appearing in person for consideration of the application, end quote. Ms. Costanis continued, it is not even discussed in the context of approval of it going to y'all, quote, the full MTLC. The discretion to approve or disapprove lies with the director. If the director denies the application, then the applicant can bring it before the commission, but it doesn't automatically go before the commission. Those were Ms. Costanis' words from February 15, 2021. The MTLC Executive Director does not have the authority to unilaterally issue a valid booting license without a public hearing before the MTLC. Ms. Costanez's interpretation and reliance on the sections she cited is highly inaccurate, misplaced, and completely ignores the public hearing required, quote, prior to the issuance of any license provided for in this chapter, as set forth in section 6.81.0.190A. Ms. Costanez appears to be erroneously conflating two separate and distinct legal processes into one, the first one being the approval of an application for a booting license by the MTLC Executive Director, and, number two, the issuance of the booting license by the full MTLC after public hearing. The effect of the conflation is that Ms. Costanez and the MTLC erroneously believe that the MTLC Executive Director has the unilateral authority to issue a booting license before or after the expiration of a previously issued booting license. In other words, a renewal. But no such unilateral authority of the MTLC Executive Director exists. First, there is no, quote, renewal application for a booting license in the code. Only an application for a booting license, one, before a new booting license is issued to a new applicant, two, for a subsequent booting license to be issued after a current booting license expires, or three, after the expiration of a previously issued booting license, as is the case for Nashville Booting LLC. Second, Ms. Costanez's erroneous legal interpretation is contrary to section 6.81.190A's requirement of a public hearing before the full MTLC for, quote, any license provided for in this chapter to be issued. There is simply no valid legal basis for Ms. Costanez's statement that an application for booting license, quote, doesn't automatically go before the commission. Third, the code simply does not provide a separate or relaxed process overseen exclusively by the MTLC Executive Director for a renewal application that supplants the current booting license application and issuance processes, which do require a public hearing and full MTLC consideration before issuance of a booting license. Section B. The MTLC Commission is the sole authority to issue booting licenses, and a public hearing before issuance is required by law. Section 6.81190A states, prior to the issuance of any license provided for in this chapter, the Commission shall hold a public hearing for the applicant after giving the applicant at least a 15-day notice of the time and place for such hearing. The MTLC Executive Director cannot approve or deny the issuance of a booting license. Only the full MTLC may do so after a public hearing. The MTLC Executive Director may only approve or deny the application seeking a booting license. The MTLC's own definition of booting license prescribes this very same interpretation, as set forth in section 6.81.005, which states, booting license, in quotes, means a license issued by the Transportation Licensing Commission, authorizing the holder thereof to engage in the business of booting within the area of the metropolitan government. The MTLC Executive Director is not the Transportation Licensing Commission, and section 6.81.020D in no way empowers the MTLC Executive Director to unilaterally issue a booting license without a public hearing before the full MTLC. Section C. Approval of an application for a booting license is not issuance of a booting license. The MTLC Executive Director's authority to approve or deny an application for a booting license is limited only to approving or denying whether a booting application meets the enumerated application requirements set forth in section 6.81020B. If the application meets all requirements of that section, the MTLC Executive Director may approve the application only to the extent that such application must still be publicly heard by the full MTLC prior to the issuance of a booting license. Presumably, the MTLC Executive Director may deny an application if it fails to include any of the criteria set forth in section 6.81020B, and the remedy available to the denied applicant includes the right to appear before the full MTLC to appeal the denial of the application. The MTLC Executive Director's approval of an application for a booting license is simply an affirmance that the application has met the enumerated requirements, but such approval is simply not and cannot be the issuance of a booting license, as only the full MTLC is empowered to issue a booting license after the required public hearing prescribed by Section 6.81190A. In conclusion, the MTLC's Executive Director's approval of an application for a booting license does not and cannot legally constitute the issuance of a booting license, as defined by Chapter 6.81.005. The Metro Code shows cogently that only the full MTLC has the authority to issue a booting license, and only after an approved application is submitted and publicly heard by the full MTLC. I thank the MTLC commissioners for considering these clarifications, invite Metro Legal's response, and respectfully request the MTLC take the following action. Number one, investigate and determine the validity of all booting licenses issued and approved by prior MTLC Executive Director Billy Fields. Number two, promulgate rules and policies making clear that a new or subsequent booting license requires an approved application to be submitted and publicly heard before the full MTLC. And three, reconsider the sanction imposed upon Nashville Booting LLC, given that its most recent booting license application, dated December 12, 2023, has not been heard publicly before the full MTLC, and no valid booting license has been issued. So that is the request for the reconsideration. I apologize if it was lengthy. Going from that point, I want to jump back to our previous meeting at the March 21st MTLC meeting. Mr. Rooker, do we have that video up?
With the Chair's permission?
Yes.
Mr. Knapp, I did say you were right.
That's not all you said. So let's go to that video, please.
You identified
Yeah,
an
no, I get that.
inconsistency between two different sections of the chapter of the code. I have bronchitis, so I can't speak very much, but Erica's going to explain.
No, we're going to watch the video of all the things that you said last month.
Mr. Knapp, you don't get to control the proceeding. I get to control the proceeding.
Mr. Chair, I would appreciate it if we would go to the video of last month's meeting so we can see fully Ms. Costanis' statement.
I don't think we need to see the video. We have Ms. Costanis here. She can say what she said. If you dispute that, then I'm going to give you an opportunity for rebuttal, and you can show your video at that point. But at this point, if you don't have anything new to present, I'm going to let legal and Ms. Haber explain the legal counsel's position on what the rules mean. And if you continue to disagree with that and you want to show your video, you can show your video, okay?
I just want to state for the record before Ms. Costanis' response, she did say that, no, you're right, but then she went on to continue to say, but here's why he's really wrong. And so it can't be both. It can't be, Mr. Knapp is right, this authority does not exist, and he pointed that out, but also, this is what the actual intention is, and there's no authority under the law for that interpretation. Does that make sense?
I understand your position.
Okay, thank you.
Okay. Mr. Knapp, as you know, we agree with you that you pointed out two provisions that are internally inconsistent. With this booting ordinance that we're looking at, we intend to clear up that inconsistency as we revise the code. It will be up to council to accept the changes, but that's our intent when we revise the booting ordinance. You know, I think what you're referring to is we probably stated that we don't think there's really a conceptual difference between the approval of an application and the issuance of a license, but they've never been treated as two different things in our experience. As far as the other contexts that the TLC regulates. However, Metro Code Section 6.81.020D was added by amendment to Chapter 681 and a 2017 legislative amendment to it. The intent of the portion of this legislation that amended it to add that section was at that time to allow the executive director to approve the grant of permits and to provide a right of appeal to the TLC, to the commission only in the event that the executive director denied the issuance of a permit.
Can you restate that section again?
Sure. It's Metro Code Section 6.81.020, subsection D as in dog. Since the amendment in 2017 was adopted later than the original language in the bill, which was enacted in 2009, and which was the source of Section 6.81.190, the passage of the 2017 bill was meant to be an intentional policy change to allow such licenses to be granted by the director, subject to a right to appeal in the event of a denial. This makes sense since that change would make the booting chapter mirror the way this is done in many other contexts in which the TLC regulates. To further bolster that this was the intent at the time, the same exact change was also made by the 2017 bill to change amendment to section 6.81.080 relating to the permit applications submitted by booting company employees for their individual permits. The 2017 ordinance amending chapter 6.81 was adopted, and it appears that a drafting error was made that no one has caught in that section. In that section, 6.81.190 was inadvertently left intact, although the language was inconsistent with the change intended in the 2017 bill. Although no one noticed this or realized it up until you, Mr. Knapp, so we applaud you for your thoroughness. To the extent that commission staff may have understood that the code chapter had been changed to give them discretion to grant these licenses and permits where the applications were fully compliant, all of the booting company licenses granted by Mr. Fields since 2017 would arguably be invalid. But following that to an even more extreme conclusion, all of the booting companies in Nashville have been operating without valid licenses since 2017. That cannot be the intent of this legislation. So while it's for the commission and council to decide policy, there's a strong equitable policy argument against interpreting that all of those licenses issued since 2017 in the context of that longstanding practice to be invalid. Further, there's a state common law principle that even when a government officer acts, quote, as a de facto, end quote, rather than a de jure enforcement officer, the acts of such officer are valid as they concern the public or the rights of third persons. So at a minimum, Mr. Fields was a de facto officer of the commission, and thus his actions in approving the booting applications unilaterally are valid. There is a basis for the commission that is to retroactively find that all the booting company licenses and permits that Mr. Fields unilaterally granted after the 2017 bill be recognized as valid if there were any, despite the existing wording of Metro Code Section 6.81.190. Thus, we recommend that we close this loophole that was inadvertently left open and amend the ordinance to remove the ambiguous contradictory language and accomplish the intent of the 2017 bill.
All right, so based on that response, it seems like you are agreeing that we should, you're agreeing with Mr. Knapp's second request, which is to promulgate rules and policies making it clear that a new or subsequent booting license can be approved by, a clearer process. I believe Mr. Knapp wants it to be publicly heard, but Ms. Haber, you're suggesting that what the commission should do is recommend an amendment to make it clear that what the intent was with the 2017 amendment.
That's correct, Chair. And as I said, we feel we can do that with the revision of the ordinance that you all will review in June. That was deferred this morning or this afternoon.
All right, Mr. Knapp, do you have any follow-up?
I would like to get a copy of your response. Do you have a copy available?
No,
No, you don't have a copy available?
it's attorney work product.
Attorney work product. I guess I'll just have to go back and watch the video, even though it's public. So, without having the response in front of me to analyze, I'm going to let the response be the final word on it for this moment. I just have to go back and take a look at what the response is, and even though that they will not give a copy of their response here today.
Well, it's just their oral presentation in responding to your
That's fine.
request.
But I just need to see a copy of it, but that's fine. I'll go back and watch the video of this hearing. I disagree with some of it without further review, and just, I would still ask to reconsider the sanction placed on Nashville booting, given the analysis set forth in my letter. I disagree that the Metro Council intended for the MTLC Executive Director to be able to unilaterally issue booting licenses. I think your own code shows you that any license before issued by this committee must be heard publicly. And I'm just simply asking this committee to follow its own rules until such time as those rules are updated or changed, or we know what the state is doing. And Metro Legal often has a way of giving a response that sounds reasonable or legal or accurate when it is not. And without having further analysis of Metro Legal's response to this request for reconsideration, I will remain in disagreement. Thank you.
Thank you, Mr. Knapp.
Chair, may I just add one more thing that I forgot
Yes.
to mention, is that staff has done some research, and they found that Nashville booting and Apex were both, their licenses were both approved by the commission. Nashville booting was in 2012, and Apex was in 2021. It's in the publicly available meeting minutes.
The suggestion there is that it is an unending license, and it only needs to be required to be heard once, and that just, there's not a valid basis for that in the ordinances of the MTLC as it presently is. If there is a periodic sort of hearing, it's not in there. And so again, my request for reconsideration is basically just asking this body to follow its own laws as written. Again, Metro Legal has a way of saying things and putting a narrative out there that sounds reasonable and legal, but often there's no valid legal basis for it. So,
Thank you, Mr. Knapp.
thank you.
Can I ask a question?
Yes.
I have a question. Swimming from the depths of everything here, are you basically saying that there was some rules and regulations that were in effect prior to 2017 that are in conflict with what appears to have been amended in 2017, and reading the policy behind the amendments in 2017 seems to be in one direction, and it's hoped that come June we'll make a recommendation to the council to clean things up, to clean up the pre-2017 rules and regulations? Okay. Has anybody seen any harm right now with the status quo in your investigation? Mr. Rooker? Anybody? Okay.
I mean, based on the argument Erica made, both the equity argument and the de facto law
Right.
argument, it would be the same result regardless, and we don't even know if it happened.
Okay, thank you.
All right, given that, Mr. Knapp has formally requested that we reconsider the sanction imposed upon Nashville Booting LLC, and so we do need to decide that issue.
Could somebody state for me what the sanction was that we did last month? I know it's in the minutes, I guess.
I believe they were put on probation, and they had to act within the following month, or by the next meeting, to refund or take affirmative steps to identify everyone and refund any fees that they may have received from booting.
In fact, that was 2 months ago, and
Yes.
they reported that they did refund everybody they could find. That we heard that, okay. I make a motion that we deny the request to reconsider the sanctions.
All those in favor?
Aye.
Motion passes. Next item on the agenda is under shared urban mobility devices. We've been asked to request to approve assignment of the existing contract with Bird to Blue Jay Transit, USFM LLC, and Spin to Phoenix USH LLC. Mr. Knapp, thank you for your time and your effort, by the way, bringing that to our attention. Mr. Rooker?
That the what?
Yes, sir, TD's gonna address the shareable urban mobile devices issues. He is the manager of that.
Sure.
Back and forth with a short HDMI cord today, but on this SUMD item, back September of 2023, we received word that Bird had acquired Spin. Following that, subsequently, December 2023, Bird informed us they were entering bankruptcy proceedings for reorganization of debt and restructuring. March 2023, received word from Bird that they were exiting those proceedings. The current contract will need to be assigned to the new LLC parent company, which is Blue Jay Transit. During this entire time they've been in bankruptcy, we haven't noticed an operational difference in the company. They are on time with their payments to the Metropolitan government. You have, let's see, Bird will be transferring to Blue Jay LLC, Spin to Phoenix LLC, worked with Ann Mickelson, Metro's bankruptcy attorney, worked with Terry Ray from procurement and contracting. I know Bird has an individual in the room today. If you have any additional questions, they've provided a W-9, the insurance documents, and the sale order from the bankruptcy court, in addition to their business license, which is the documentation that was requested from finance and procurement to approve this assignment of the contract.
Is this being presented as a package, Bird to Blue Jay and Spin to Phoenix?
Phoenix, yeah, I believe.
Okay.
So there is one overarching LLC company that owns both. Each individual contract is under a subsidiary LLC. And if there's any additions to that, I believe we have Stephen here in the room.
And you have verified that Blue Jay and Spin meet all the requirements that Bird was required to make or meet?
Yes, sir. So Ann Mickelson and Terry Ray from Finance Procurement sent us the documentation that we would need to verify, which again was the W-9, the insurance document, business license, and the sale order from the bankruptcy court. We have verified all that documentation and have it here.
One of the questions that I asked relative to that is the applicant, I believe, is supposed to show us that they are financially in good standing. I'm curious if there's a purchase, a P&L statement available, a balance sheet available, anything that would show current cash My concern is that they're not adequately funded to maintain the fleet, and that, look, when you're in a bankruptcy and when you're short on cash, sometimes it's hard to get cash to people to put new tires on or to fix the brakes. I've certainly, I ride the Birds and the Limes, wear a helmet, I don't ride on the sidewalk. And the quality of the equipment has varied. I really enjoy them, don't want to see them go, but also want to ensure that they're maintained really well. And I'm curious their current cash position and burn rate.
Would you be asking that at Blue and Phoenix versus Birch?
Yeah, I mean, you would,
Whoever's acquiring
I
it.
think, one of the things that we ask for anybody that we're providing a license to is some sort of statement of financial viability. And so you would ask that, I think, of Phoenix, and Blue Jay Transit, because when you look through all these different LLCs that rolled up, I know Nashville's profitable, but I have no idea about the city of Bismarck or Shiva Scooter Panama, right? Or there's lots of good ones in here. How they're doing and how the cash is projected to burn, and we just want to make sure our fleet's protected.
Completely understand the question. The documentation that was provided is what Ann Mickelson required us to compile, as well as procurement, so legal could weigh in.
And I guess that was a question that I had asked for prior to the meeting, via email, to have a copy of any sort of proof of financial viability. The statement from the bankruptcy court doesn't show what their cash position is.
I think a representative from Bird is
Great.
here, if you'd like to hear from them.
I'm so sorry for what you guys are going through. Really unfortunate.
Yeah, hey, Commissioners, my name's Stephen Henry. I'm with Jigsaw, local firm here in town. We represent Bird. I think you're used to seeing my colleague Sam Reed, who's not able to make it today. But yeah, so this, sorry, I'm just trying to answer this on the fly for you. But we, as you mentioned, TD gave a great history of where we've been over the last several years. And to your point, Commissioner Hayes, this has not been a fun time for the company, but they have emerged from this the bankruptcy proceedings and this new reorganization that you're seeing here. This is we're currently going through all 350 markets that we're in and reassigning these contracts to these LLCs. I don't personally have an updated P&L available to me, but we do have some supporting documentation on this change, some FAQ that Bird's assembled internally that provides a little bit more information on this reorganization. I do think I can try to get you as much of the financial position as I can. We're being told that we're cash positive right now, but don't have the exact numbers available to me, so I can provide you some information after this meeting.
Well, I have a question. I'm a little confused now. Is Bird simply assigning these contracts to some subsidiary underneath them, or I heard there was an umbrella company, and then we've got Blue Jay Transit and Phoenix. What's the structure?
So there's a
Is Bird selling to a new company?
no,
Okay.
Bird's just
Yeah, I knew, but yeah,
Right.
but you came out of bankruptcy.
All of these contracts to Ringo and White to debt. And they got I think a $25 or $50 million cash infusion from an investor that I'm assuming has a burn rate because you've got a lot of unprofitable markets.
So what's the structure?
So, following the bankruptcy, they've spun up a new parent organization, but still controlled by Bird. That has these two LLCs. One will operate Spin and one will operate Bird, which are now part of the same parent company after the acquisition of Bird's acquisition of Spin.
Wasn't Bird operating separately in, I think, Canada?
I'm not sure of that, but
Okay. Because I thought there were two separate Birds. Well, we do have, maybe legal could speak to this, we do have some requirements for bond in the current, it's either in our rules or the law, I'm not sure which one. Do we think those are sufficient? I think one of them is actually based on each scooter, if I remember.
I have to pull up the section about the bond question, but we were just discussing how the contract between Metro and Bird states that the certificate of public necessity and convenience is not transferable or assignable except as follows. Contractor understands that neither this certificate of public necessity or convenience nor any rights and obligations of the contractor, that would be Bird, hereunder shall be assigned or transferred in whole or in part without the first prior written consent of the TLC and adoption by Metro. So any such assignment or transfer shall not release Bird from its obligations hereunder. So the reason this is before you today is because of that contract provision. So they're asking for your approval for the assignment. And then the assignment, I will go before the council for approval. The contract also mentions the bond, Commissioner Rogers. During the term of this contract, contractor shall, at its sole expense, obtain and maintain in full force and effect for the duration of this contract, including any extensions, the types and amounts of insurance described below. Okay, that's the general provision. Bonds. Contractor shall provide and maintain required bonds as required by the commission. The bond, which is hereby included by reference, shall cover contractor's performance under this agreement in addition to the bond funds being accessible to the Metropolitan government for the purposes spelled out in the chapter and regulations.
So it's an attachment.
So it was an attachment, which the bond is attached to the contract. But I don't think we have that attachment in front of us at the moment.
Okay. Did our staff or procurement or anyone else check to see if these bonds are still active and paid up, and what the hell you do with bonds?
So generally procurement does go through all of those things. I'm looking through some stuff right now. If you just give me 1 second. I see the insurance, the active insurance policy for Blue Jay Transit. I can try to find out.
I can
try to find out and let you know. I don't think we have it in front of us right now.
We would need the surety on the prior bond too, or a new bond would be fine too. Just saying that the contract as assigned to Blue Jay is now covered and protected by them.
Erica, can you go back to the assignment provision?
Sure.
And
Oops.
did you say that Bird is still legally obligated even if we approve assignment to Blue Jay Transit, for example?
Bankruptcy court might preempt.
It does say that. It says that any assignment or transfer shall not release contractor from its obligations hereunder, but the bankruptcy court could preempt that, I would think. And the assignment language itself, maybe.
Well, my question is, by approving the assignment to Blue Jay and from Bird and the assignment to Phoenix from Spin, assuming this language is correct, the commission really is not letting Bird or Spin out of any of its present obligations anyway, and notwithstanding what the bankruptcy court might do, but the TLC doesn't have any control over that anyway. So if by approving the assignment,
That's true.
there's no,
He's right.
the commission, the city is not losing any ability to say, Bird, you're still responsible, or Spin, you're still responsible if we find out Blue Jay and Phoenix are underfunded, for example.
They may not actually exist as an entity, so.
She's saying and they may not even exist as an entity, so it may be better to have a bond from the company that's doing the actual work.
And Bird wouldn't necessarily then meet the requirements to have a license by filing bankruptcy because they're not financially viable as a company. They couldn't hold the license.
I don't know what this is.
There would be nothing to go after.
Show my ignorance, in bankruptcy, what would happen to any insurance bond that they're required to have under the rules? Does it disappear? Assumably, they're paying the insurance.
That's a question that's above my pay grade.
Okay.
I will say in my
Good.
experience, on the real estate side, at least in my experience, bond is an asset that may transfer to the new entity. If it exists.
But legally, we're requiring them to have the bond regardless of who it's assigned to, correct?
I'm sorry, what was the last?
I mean, under the, I don't know if it's in the contract, something's in the rules about a performance bond. We're requiring that regardless of whose name is on the contract, correct? I mean, all of that transfers as well, all the requirements that they have to meet.
So, yes, the contract terms have to be fully assumed, including that obligation.
Okay.
So, even though the bond is under Bird and under Spin, under our rules and regulations, the bond needs to be under Blue Jay and Phoenix. Is that a correct assumption? I mean, it sounds like the only other option we would have, Mr. Hayes, is just to say no, and then all the scooters would have to be taken off the streets.
Yeah. But I mean, if, my, again, concern is that they don't have the cash flow to maintain the scooters and somebody gets hurt and there's a bond in place, or there's not a bond in place to protect, there's not adequate insurance in place to protect.
But that's an issue regardless of whose name is on the contract, correct?
Presumably procurement is taking a look at those financial
Right.
issues. Yeah, we're kind of a public need and necessity.
Insurance documents were provided, and the documentation Terry Ray from procurement asked for, again, was the W-9, the insurance, business license, and sale order.
Okay. And maybe I don't understand the legality of it. Is Bird still a legal entity owned by these companies? Or is it?
There's a new parent
Right.
entity instead of Bird, but my understanding is that all of Bird's prior obligations and operations are all completely the same and staying intact under this
Right.
new entity.
So their assets and their liabilities and I guess contractual responsibilities transferred as well?
Yes, they're just being assumed by the new entity.
So the question is whether we accept if we accept that you have all those adequate requirements in the current contract.
That's my understanding.
Okay. And procurement presumably has looked at all of that.
I'd love to assume so.
Yeah. So do we?
I guess upon request to see a copy of what procurement provided, they didn't share it with us.
And we can even ask them to come here
Yeah.
and present what they looked at and give us assurances that these things have,
That they're financially
Blue Jay
viable.
Transit and Spin have the insurance and have the bond and.
Yeah, I'm being told that we submitted all this to either through procurement or Metro Legal. I wasn't personally involved in that process, but.
Did they put anything into writing to us? Ricky? They didn't?
Not procurement, I don't believe procurement said anything.
The only thing that was sent to us was
The W-9?
W-9 and the insurance document.
I didn't even see that.
And there's an umbrella in that, but no bond.
You know, the issues we're talking about would be true regardless of what name is on the contract, correct? I mean, it was an issue before they became bankrupt and.
I raised the issue with the director in November because of the SPAC merger and
Right.
the declining cash balance, and look, we're talking about giving them possibly bikes, right, and more and more.
Well, no, we've already done that.
Oh,
We
I
did
see,
that.
more bikes.
We did
More
that,
bikes.
we did that 3 years ago.
Right, but we're talking about even more.
No, we haven't reached what we did 3 years ago. So it's not beyond what this commission has already approved. And what's in a current contract, we haven't reached either one, so we're not giving them anything else.
Well, Mr. Hayes, do you want to make a motion requesting for this additional information that you're wanting to see? And
I'd move maybe tell me this, when did we last approve the one-year contract?
About this time last year.
Is it?
It would be in June of this year, for a one-year annual renewal.
So I guess I'd be okay to go ahead and approve the assignment today, but in advance of the annual renewal, I'm hopeful that they can provide all of the information requested.
So just point of clarification for me. Without assigning the approval, basically what we are doing is requesting that all the bikes be pulled. All of them.
Everything, yeah, which is painful for Nashvilleians.
Because you wrote one last time.
I know.
And I don't think, I mean, tell me if I'm wrong, but we have the authority to ask for, requirements in the contract at any time, correct? I mean, if we want to know, what their financial position is, whether it's Bird or Spin or Phoenix or whatever, don't we have that authority? I mean, we can say, you signed this contract, prove to us at this particular point that you meet the requirements in the contract.
By the,
Is that a question for legal?
Well, I guess whoever can answer it, yes. I mean,
So, did you just say you want, I'm having trouble hearing.
The question from Mr. Rogers was, as a commission, we can ask for information or substantiation by the SUMD companies at any time pursuant to the terms of the actual contract.
yes.
Is that correct?
Search.
so I guess my question is, we could reassign the contract today and ask for, any information that we want to see or need to see, or ask procurement to do it, or whoever the heck's in charge.
Could we even reassign it conditioned upon production of the financial viability, the bond, and the insurance?
Or if we've got to renew the contract anyway, we could do it at that point. And it's in their interest to get us the information before then, obviously.
Chair, may I, I've just received some information from procurement and they say that any requirements of the contract would have to be fulfilled by the new entity. I think they are providing the bond with the permit, and then NDOT can confirm that. But
The contract requires that they are financially viable and that they prove to us that they're financially viable. Bankruptcy,
I'm trying to find it.
in and of itself, doesn't show that you're financially viable, right? They've gotten crushed by the rise in interest rates, like lots of people have, and going into markets unprofitably, of which we're not one. We're a very profitable market. I'm told.
so
That's
we could
hard to say.
also,
We're a profitable market.
Yeah,
I mean,
I understand what you're saying.
they're publicly traded, right? So you can read all these disclosures about them and what,
Right.
I mean, there's,
And they have pulled out of some markets,
Yeah.
correct? I mean, you've exited some cities, right?
but my concern primarily is the public safety of Nashvilleians and the visitors, and that there's adequate cash to invest in the bikes and in the scooters to maintain them, and to pay our fees, certainly.
Yeah, and I
In
don't.
other markets, they were delinquent in fees. So I've read.
And I don't know what, I know some cities actually do, well, the same thing we do with taxis. They actually inspect the equipment. I think Seattle does that, used to at any rate, on a regular basis. So you can look at it as if they have cash, we assume they're using it properly. Or do we, do a direct inspection of their equipment? That's a probably a discussion for another day. Well, did we have a motion? I'll make a motion that, we do?
Yes, we need a motion.
Oh, we need a motion. Okay, I'll make a motion that we approve a reassignment of the contracts to Blue Jay Transit and Phoenix USH. Who thinks up these names?
And we have a second. All those in favor?
Aye.
Any nays? Motion passes. We also have been asked to consider some proposed amendments to the actual current SUMD contract. Ms. Haber or Mr. Rooker?
Before we go forward, layman here, what we approved was until June.
Yes.
In essence,
So
yeah, that's true.
we basically just gave them a stay till June. To the next,
Until
okay.
the renewal.
Making sure, making sure.
So now we've got some proposed amendments to the current SUMD contract to consider. Mr. Rooker?
I believe legal's going to address this, and staff's going to recommend that we defer this contract.
Yes, we had some proposed amendments to the current shared urban mobility devices contract. However, looking back at the regulations, any amendments to that must be done pursuant to TLC rules and regulations, not pursuant to an amendment to the contract. So in order for you to review regulations, the public also has to have 2 weeks' notice of the regulations. So we need to have the regulations out there for 2 weeks, so the public has an opportunity to review, comment, come in, and then you can approve the amendments by regulation, but we just didn't have enough time to get it on this agenda and get the proper notice. So we're staff with a staff recommendation asking you all to defer the proposed amendments until
May, June.
Okay, now you're going to have to explain this to me again. Why the contract is considered a rule? I understand the 2 weeks for rules, but I thought the contract legally was separate from the rules.
So the contract incorporates the rules by reference.
Correct?
So the text of the rules become part of the contract, even after you change them.
Correct. So why do we have to treat the contract as a rule?
I don't think that's what we're saying.
I don't think, I'm sorry, I don't see that.
I don't think we're treating the contract as a rule. We're just saying the rules require the contract to be amended as a rule. We have to
To make the
adopt new
change,
rules.
You have to change the rules, not
Yes.
the contract.
Yes,
Could you read that part of the law?
sure. That's what I'm looking for.
I saw it a second ago.
Sorry, I'm
I don't see that.
regulations.
While they're doing that, Mr. Rooker, are we reviewing all SMUD contracts in June? Is that correct?
Yes, sir.
Okay. So if we're going to actually,
It's just
just one? Oh.
Chair, if I may. The contract will expire without a motion to renew for another year from this commission on June the 12th. So it will need to come on the May meeting agenda in order to have that done before June.
So we'd have to look at this proposed amendment before we vote on the
We
contract.
have to do it in May, for sure, because the contract comes,
Yeah.
yeah.
Okay.
Contract runs out before.
But he wants to.
June meeting.
But we were looking at this proposed amendment to the contract in order to effectuate it in June? Is that what we were? Yeah, to approve it in May,
There's 3 contracts.
right.
We don't want to change something just for one party. We change the rules, we change it for everyone.
Why can't we, I don't understand. I mean, the contract says they will obey our rules, period, and that we can change them at any time. That's in the current contract, correct? So I do not understand why we're treating a contract as a rule, just because the rules are a subpart of the contract.
So, yeah, so it's, section 1 says, oops, I went past it, crap. This agreement consists of the following documents.
What are you reading from? I'm sorry.
The contract. The most recent version of Chapter 1262 of the Metropolitan Code and the related regulations promulgated pursuant to its authority by the MTLC, incorporated by reference, as may be amended from time to time by the Metropolitan Council and the MTLC, collectively the chapter and regulations. And then in 3, it says, yes, please.
Where are you?
It's past 2, I have to go down. I can't go down. Oops, too far. Oh, shit. Top of 3.
Contractor hereby agrees to and accepts the terms and conditions contained in the chapter and regulations which are incorporated herein by reference, including but not limited to those relating to the following areas as set out in Metro Code Section 12.62.020 subsection C.
So the rules are the substance
Substance of,
the obligation.
okay, they're part
If you
of
want
it.
to change the substance, you have to change the rules.
I don't agree. I don't see that.
What are
I mean, the
proposed
rules can be
amendments?
changed without changing the contract, correct?
No. If the rules are changed, the contract will be changed.
Right.
Because it incorporates the rules by reference.
And that I understand, but you're treating the contract as a rule.
I'm not intending to. I'm just saying because the rules are incorporated, in order to change the contract, we need to change the rule.
I guess I'm slow, but I don't understand.
So the proposed amendments, because I haven't seen what those are, but
Well, I'm bringing all this up because I didn't like it at all and was prepared to totally change it. You know, my point is, I thought this was what you were saying, what was in this proposed amendment are rules, which should be handled as rules and not put into a contract. Am I correct?
Yes.
Okay. But I don't see why that makes the contract amendment a rule. I'm sorry, I just don't understand. I mean, the contract basically says they'll obey our rules no matter what we do to change them. So, I guess I'll lose this argument.
all right, so
I'm sorry.
does anyone want to make a motion? Staff's recommendation is we defer to the May meeting
I don't know if it says that somewhere.
the proposed amendments to the current SUMD contract.
I'll make that motion, that we defer for 1 month.
I'll second that.
Could I speak to the motion? I
Yes.
want to make sure, so the amendment that you gave to us that I don't like and want to change is going to be published 2 weeks prior to the next meeting. Correct?
Yes.
Okay. So I'll try and change it at the next meeting. Did all that work?
All right, so we have a motion to defer to the May 2024 meeting, second by Mr. McNally. All those in favor?
Aye.
Any opposed? Motion passes. Next item on the agenda is under entertainment transportation. We've got Metro legal guidance resulting from SB 2898 and HB 2642.
Yes. This is some other state legislation that's currently pending in the General Assembly. It is about to pass, we think, and it's regarding entertainment transportation vehicles. And basically, it says that, in a nutshell, any entertainment transportation vehicles that already have permits are essentially grandfathered in. The commission cannot refuse to renew a permit to a business that provides entertainment transportation if the commission issued the permit to the ETV, I'm going to abbreviate, ETV, prior to the effective date of this act that's still pending. Nor can the commission revoke a permit issued to a business except for, issued to an entertainment transportation business, except for good cause shown in an administrative hearing. Good cause means a material violation of a state law or a municipal ordinance, rule, or regulation governing the permit, which may be demonstrated by a knowing failure or refusal to comply with such law, ordinance, rule, or regulation. Another form of good cause would be the disuse or dormancy of a permit for a period of 6 months or longer prior to the commission taking action to revoke the permit. So provided that start date for calculating a 6-month period of disuse or dormancy begins after the effective date of this new state legislation. So if you were going to revoke a permit for an ETV for dormancy or disuse or not renew, you cannot do that for 6 months after the effective date of this act.
Disuse or dormant?
That's really all we have on that, so I'm happy to take any questions if you have any.
Prove somebody's been dormant.
Are there requirements for renewals?
The requirements for renewals are set forth in the TLC rules and regulations
So they have to meet
and the
the
Metro
requirements.
Code, so they would have to meet the requirements. But for those who have currently existing permits, none of them can be revoked except for good cause, nor can you decline to renew them unless there's good cause shown, or they've been inactive for 6 months after the date of the act.
All right, thank you, Ms. Albert. Is there anything that we need to do right now?
Not at this time.
Thank you.
You're welcome.
Next item is under disciplinary hearing. We have a complaint by Devin Majors against Apex Parking Enforcement LLC, which was deferred from last month. You may proceed.
Well, first, thank you to the Transportation License Commission for hearing my hearing, and also for your service to the city of Nashville. And in the sake of this committee's time, I'll be concise. From June the 5th of 2023 to January 7th to 2024, roughly 7 months, Apex Parking Enforcement LLC operated without a valid license. During that time frame, on January 6th of 2024, I was booted by an employee or agent of Apex Parking Enforcement at 9:29 p.m. At the Edge Hill Village parking lot. Apex Parking Enforcement portrayed themselves as a legitimate booting company and as if they were licensed, as evidenced by the notices they placed on my vehicle and them collecting payment. These actions are a direct violation of the Metro ordinances, section 6.81.005. Therefore, I am bringing these allegations seeking that Apex Parking Enforcement be held accountable for all the illegal licensing, illegal booting that occurred during that 7-month unlicensed period. Furthermore, based on this committee's precedent, I'm seeking sanctions equal to similarly situated booting companies that have been punished for operating without a license, including requiring Apex Parking Enforcement to refund all persons who were booted during that time frame, placing them on probation until all refunds are refunded. I also think that it will be just for this commission to revoke Apex's license, given that they operated without a license for 7 months, which I think is beyond excusable. I believe that my exhibits speak for themselves. Mr. Wharton's statements to the news where he's admitted to booting illegally all serve as justification for the sanctions that I'm seeking today. And I welcome any questions from members of the commission regarding my allegations.
Mr. Majors, did you go to the License Commission Board and ask for a copy of Apex's license to do business?
No, I went to the Metro Transportation licensing websites and I pulled a list of active permits. And from that list, I was able to see that their permit ended on June 4th of 2023. And then they renewed their license when I seen a new license get put back on the webpage. And that was issued January the 8th of 2024, so 2 days after they booted me.
Ms. Costones, have we validated that that's correct, that Apex did not have a license from June 23 to January?
Legal has not independently done so, no. We have not been involved in this case to date.
But I believe staff has some information.
We do have information. Let's see, the email was sent to Apex on June the 2nd of 2023, that they would expire on June 4th of 2024. He made application. 2023. The Apex came in and made application and payment on January the 8th of 2024. Four?
Yeah.
For a license that expires.
For a license that expires.
2025.
That is correct, yes.
2023.
His license expired in 2023.
They were notified on when that they were up for
They were
renewal?
notified by email on June the 2nd of 2023, and it expired on June the 4th of 2023.
Okay.
Operated by a license from June 4th of 2023.
They were not licensed between June the 4th of 2023 and January the 8th of 2024.
Same information that he
Yes, sir.
provided.
That is correct.
So it is correct information.
Correct.
Is there anyone is there anyone here from Apex, representing Apex?
Mr. Majors, I have a question before we go over to Apex. In your complaint, your consumer complaint, you indicated that you had previously filed a complaint before. Was that for the previous meeting when this was deferred?
The previous complaint that I filed actually didn't make it to a hearing. That complaint it was withdrawn, and it was related to the attire and the conduct of Mr. Wharton during the booting encounter. But it was not related to the unlicensed nature of the company.
When were you refunded your booting expense that you paid?
I believe it was shortly, maybe a week after, so.
A week after what?
January 8th, well, January 6th of 2024. So like a week after that.
And you had filed a complaint by that time?
Yes, I have.
Okay. And was it the first complaint or this new? It looks like this one was February 20th, so.
Yes, so the February 20th complaint is, it relates to the license. That was not a discovery that I had until after the fact.
Okay. So just chronologically, so I understand, you get booted, you get refunded, you file a complaint, you get refunded, and the complaint was for the conduct of the person who confronted you, and then you filed another complaint on February 20th that dealt with the licensure issue.
Yes, sir.
Thank you.
Is there anyone here from Apex? If you'll please come forward. And Mr. Majors, I should have done this on the front end, but if you would please repeat after me. I swear or affirm that the testimony that I have given
I swear and affirm that the testimony that I have given
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you. Hello, sir.
Hello.
If you'll please repeat after me. I swear or affirm that the testimony that I'm about to give
I swear or affirm the testimony that I'm about to give
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you. If you please state your name.
Clifford Wharton.
Mr.
Does this
Warden.
work?
It doesn't sound like it's working. I'm not
I
sure.
think they're just recording.
Okay. Mr. Warden, do you have a response to the complaint?
I was unlicensed during that time. I did submit the application to the old address, which they have a record of that through email. Apparently, because it was sent to the wrong address, it wasn't received. They let me know their updated address. Had my wife send it through our mailbox, apparently it wasn't received. So during that time period, I was unaware that I was unlicensed. I should have followed up with that because I didn't get any word back from the department. Once I found out that of the complaint, I immediately went to the office and updated the permit that same day. So that's basically what happened.
So, you sent, when you were given notice on the 2nd,
Mm-hmm.
you're saying before the 4th, you actually sent it, and this is in 2023?
Yes.
You actually sent an application?
Yes.
And for 7 months, you did not receive a reply? Nothing crossed your mind as that that's a long time, even snail mail, not to get a reply?
Right. I mean, a lot was going on. My dad died, and I had left for some time period. So there was just a lot going on, and I should have, like you said, I'm responsible ultimately to know I should have followed up. I didn't.
I have a couple questions. You said that when you saw the complaint,
Mm-hmm.
and that's the complaint by Mr. Majors,
Mm-hmm.
it's yes or no? You'll need to say yes or no, please.
Okay, what's the question?
The question is, you saw a complaint by Mr. Majors, right?
I received an email from the department saying, hey, we received a complaint from Mr. Majors.
And then did you just testify that you then went down and paid the fee for your license?
Yes, I went into the office and paid it immediately that same day. I received the email, yes.
All right.
The email that was like later on, the six months later email.
Let me just make sure I'm really clear when you
Yeah.
paid your fee for your license.
Mm-hmm.
Was it after you received notice of Mr. Major's complaint that you were an unlicensed or
Yes, that's when I
operating without a
became
license?
aware that I was unlicensed, and I went that same day. And
The complaint was about behavior at that point.
it was.
It was later.
The complaint about, Mr. Majors, am I reading this correctly, that you signed this complaint? Do you have your complaint in front of you?
Yes, sir.
What date did you file your complaint? About the license, I should say.
Oh, I thought that was when you were.
No,
January 6th, I believe.
January 6th.
Complaint about the licenses.
Yeah, that's well.
Yeah.
I've got a copy here if that would help.
It's,
What date did you sign this complaint?
we could, the first complaint on
No,
January.
the complaint regarding the license.
The complaint regarding the license was signed on February 20th of 2024.
Mr. Rooker, do I understand that Apex came in and paid for their licensing fee on January 8th of 2024?
That is correct, sir, yes.
More than a month earlier than the complaint filed by Mr. Majors about the
Well, there was
license?
The original complaint
Mhm.
was filed on January 6th.
About the conduct of?
About the conduct.
Yeah.
That complaint was settled and taken care of, to everyone's satisfaction. The payment, I'm understanding, the payment for the license was made on January 8th with application and payment, 2 days after the original complaint.
About
Conduct, yes, sir. Then, on February the 20th, the complaint came in about the licensing issue.
And I'm just pointing out that it appears that he paid it substantially before the complaint was filed about the licensure issue.
That's correct. It was also filed 30 days outside of the rule. The complaint, the second complaint 30 days beyond the date of the incident,
Okay.
which is your rule.
I have a question. What prompted you to make a payment in January based on the complaint?
I received an email from the Transportation Licensing Commission that says, hey, we received a complaint on you. We are unlicensed.
Oh, it notified you then that you were unlicensed?
Yes. So I immediately, that day that I received the email, he said 2 days. They didn't let me know, I guess 2 days later in email form. I immediately went and paid the fees and did the necessary steps.
Okay. The complaint wasn't concerning the license, but it
I
notified
think the
you
complaint
in
was
that.
like my ID badge, which a lot of people think it's here, but I have it here. I think he mentioned something like he thought I was carrying a gun, which I was not carrying a gun openly. Things of that nature. I didn't break any laws or anything as far as, you know, regarding him and the booting. Like he didn't pay. I booted him because he didn't pay. And
Mr. Majors, your complaint nonetheless is that there was 7 months of operations where people, including yourself, were booted and paid fines. You received a refund, I guess as a settlement to the original complaints, but you feel that there are others that are entitled to the same because of the licensing or unlicensing issue.
I would agree with that in the most part, but I don't, in terms of like settlement, I didn't waive my right to bring any future
Sure.
claims against them. But I brought the complaint as accountability. When I discovered that they didn't have a license for 7 months, I thought that that was unfair to people who couldn't afford an attorney to go prosecute a $98 boot. And I was a victim of it myself, so that's what led me to bring this complaint.
Well, I think for me, the concern is kind of the precedent we set with Nashville booting. That we're not here as a paper doll committee. If we say you need a license, you need a license. If we say you can't drink on board your vehicles, you can't drink. If we say it's a noise ordinance, there's a time period you can't operate. Those things are put in place for public safety and this as far as being licensed as a form of accountability. This office said that they did send you a notice that your license was coming up for renewal, and I understand your father passing, my mom recently passed herself, but I still operated my business. I still got my licensing. You know, I still got permits that I needed, and as a business owner, we are out in the public and we are serving the public. Unfortunately, those things have to still be involved or put aside in our mind to operate our business. It is unfair to the public. You know, I can't go around and hook up somebody's car because I see it parked under a no parking sign and tow it away without a non-consent license. No more than you should be able to boot without that license as well. So having set the precedent for Nashville booting, I would say the same, that Apex be required to show proof of a list of all the people that were booted during the time that they were not licensed and make refunds to those people.
I think we first have to have a motion on Mr. Major's complaint that was filed here, whether it was valid or not. And I would move that we find Apex was operating without a license from June 2nd, 2023 through January 8th of 2024.
June 5th.
I'm sorry, was it June 5th?
Yes.
All right. I amend that motion that I make a motion to find that Apex was operating without a license from June 5th of 2023 through January 7th of 2024.
I second that motion.
All those in favor?
Aye.
Motion passes. Yes.
It was my understanding of the committee's rules about the 30-day time frame that is within the power of the commission to hear cases that were brought outside of that window, and it wasn't like a firm deadline for when a case had to be brought. Is that a?
Yes, Chair, he's correct about that. The rules does say all complaints must be filed within 30 days from the incident. However, the commission reserves the right to hear complaints outside of those parameters.
Thank you. That's correct.
I think we heard it.
Do we need to make a motion to hear it?
We moved on,
Okay.
so I think that
All right.
tells us we did it.
All right.
Yeah, thank you.
So we avoided statute of limitations.
Yeah. I mean, I think we do have a precedent, do you know, of
Yeah, I
being
think it
serious
was
about the license, and if we treat one company in that manner, I think we need to treat another company
Yeah,
in the same manner.
Yeah, I believe it would be unfair to Nashville Booting, even though that was a movement against them, as to require them to do something because of not having a license and not require the same company to do the same. So again, I guess, am I in order to make the motion now, Chair?
Yes.
You are.
I'd like to make a
Probation.
motion that Apex refund and give us a list as well as all patrons that were ticketed during the time of, what is it, January, June 5th of 2023
January 7th.
to January 7th of 2024. And subsequent to that, that if that is not provided to the council, that a suspension be placed on the business until we get the required information.
I think our model last time was to put the company on probation, pending a list and efforts to make refunds.
Okay, well, let's do that.
Commissioner Carr, you said cars that were ticketed. Did you mean cars that were booted?
Cars that were booted.
Okay.
Sorry.
That's okay. Just want the we just want a clear record. Yes.
When you're booted, the boot's obvious, but there's tickets also. So-
Okay, I think we need to make the motion a little more clearly for the benefit of Apex, so it knows exactly what is being required of it. So what is it that you're wanting Apex to do by May, our next meeting?
To provide a list of all patrons that were booted during the period between June 5th of 2023 to January 8th of 2024.
And proves that they reached out.
And make the process of refunding them.
All right, that's the part that I think needs to be a little clearer. What do you mean by, and make the process of refunding them?
Contact those patrons. Offer them a refund of whatever charges that they were charged for booting.
Okay, so that does not mean they have to have physically refunded them by May. That just means that they need to contact them and offer the refund, and then what?
And provide that back.
Okay.
And by our May meeting. Or do we need to make that June? Is May already full?
June, if that's okay.
By our June.
This ought to be something that would be quickly, give us a quick status on it. I think it's important to move expeditiously on this matter.
Yeah. Can I ask us to read from the minutes what our motion was for the previous company? Because I feel like we ought to be consistent.
I agree on the consistency. I think it was practically a little different because we were talking about a 30-day time frame versus 7 months.
Got it.
And so I think just practically, it's going to be more challenging for Apex.
It's going to be very difficult to get all that information in a month.
But, and it may be that this aspect of Mr. Carr's motion isn't difficult, but the actual refunding of every vehicle that was booted in a 30-day time, to have that happen within a 30-day time period may be unrealistic. So I don't want to make it an impossible task. That's what I'm concerned about.
But I'd like to keep their feet on the fire and at least get a status report as to, I think they could try to identify the people from this 6-month period of time and give us a status report.
Thank you.
Here it is.
Because interestingly, we did hear from the previous company that some of the folks didn't want their refund.
That's okay.
Well, actually, you know, the language of our ruling is actually pretty clear. So, you know, Mr. Carr, you could, in your motion, ask that Apex identify every customer by providing a list, and then identify who's been refunded to date and who remains to be refunded.
By our June or May? Do we want an identification in May and by June, a refund list?
I think it could all be May.
And then we may move them along to June to see where they are in June. You know, they may have 25% of them done by May, and then, you know.
We can for sure have a status report
Yeah.
that says how far along the company is.
I just do one small lot.
Well, that's encouraging. So, you know, we did hear from the previous company that some difficulties because some things are credit cards and some, you know, whatever, you know, cash on the spot.
It's hard to call someone because we don't have that information. So
Right.
we just go to the merchant and say, hey, this is the card numbers.
We need to refund them.
Yeah, but we make a request, a special request, I believe.
Okay.
It's not a normal request. I don't know the process of that.
You can get a good start on this though by May, can't you, to tell us who?
Yes.
Okay.
And maybe you get with Nashville and see how they did it.
It's hard to get a hold of them.
Go park somewhere.
So,
boot you. No.
So Freddie, if I can offer a friendly amendment, I would suggest that our motion read that Apex enter into a period of probation indefinitely until the following conditions are met. That at our May TLC meeting, they provide a list of every customer who was booted during the 7-month period from June 5th to January 7th, and identify for us those customers who have been refunded and who remains to be refunded with the intent that all customers booted during that time frame are refunded.
Clear. So, since you've got it in your mind, I'm gonna let you.
I'll second that amendment to the motion. So.
Any further discussion? All those in favor?
Aye.
Motion passes.
Can I bring this up?
Yes.
I want to take a matter out of order. A gentleman approached me earlier. Mr. Long, can you come up a second, please? I understand that you have an appointment that you have to leave here at 2:30, and that you were on the application review today for the OPVH driver application review for Jason T. Long.
Yes, sir.
Next to the last thing on the agenda.
Yeah. So,
Oh, yeah, turn the
Well,
cameras on.
he was wanting to defer because he had to leave.
oh, it's just a deferral?
Well, that's what he
All
says
right.
here. If that's, all right. You're asking for a deferral because you need to leave by 2:30?
Yes, it's the teams, yes.
Okay, it was probably going to be deferred till June then.
Okay, that's fine.
Is that okay, Mr. Rooker?
Yes, sir.
Okay. You're free to go.
Oh, thank you so much. Will I get a letter in the mail or? Yes, okay, thank you so much.
Oh, I would make a motion to defer Mr. Long's application to the June meeting.
Second.
All those in favor?
Aye.
Motion passes.
Thank you so much.
Thank you.
Next item on our agenda is also under disciplinary hearings. We've got Grant Rosenblatt's complaint against Old Town Trolley for operating during the hours of 4 to 6. And the TLC Commission.
I defer to the last, there's two others.
Okay. There's been a request to defer Mr. Rosenblatt's complaint to the heel of the disciplinary hearings agenda. We've also got a request to review Nicholas Lyons' complaint against Old Town Trolley for also operating between the hours of 4 to 6 p.m. Yes.
We're requesting a deferral for all three of these hearings. We're happy to come back in May or June, whenever you prefer. I know May's docket is getting long. We did not receive the copies of the complaints in a timely manner, and it was after the deadline to fully review it and prepare an adequate response. So in the interest of ensuring that our due process rights are not violated, we're requesting a deferral.
And then we've also got Mr. Winters complaining against Old Town Trolley for operating during the hours of 4 to 6. And he's also alleged other violations set forth in Metro Code Chapter 211. Mr. Winters' complaint, he's filed a couple, actually 3. One against Old Town Trolley, one against NDOT, the TLC director, and the TLC commission, as well as a third one against the NDOT director and the TLC commission. So it's my understanding, Ms. Lamb, you're asking for all 3 that I've just mentioned to be deferred to the next available time slot?
Yes, sir. All 3 that are specific to Old Town Trolley, those are the 3 that we're requesting to be deferred.
Chair, is it appropriate for me to ask a request in addition to that?
Well, I was about to ask the complainants what your position was on the request to defer.
I'm just gonna,
Michael Winters again, sorry. First off, let me say, my complaint, Grant's complaint, and Nick's complaint, this is not an attack on Old Town Trolley. That's not our agenda, that's not our goal, that's not our purpose. Our purpose is more around rules. So today, my goal in my complaint, and I'm sure is the process of those gentlemen over there, the goal is really not to get Old Town Trolley in trouble. That's not the goal. The goal is to figure out why the rules allow them to operate. So what I would like, if they want to move it, I would simply like them to simply make one statement for me. Were they given a special route to operate on, and are they operating on it, yes or no? If they can answer that question, I have no problem moving my complaint till the next month.
Well, that's actually having the hearing, so we're not going to do that. We're either going to have the hearing or we're going to defer.
I'd like to be heard today. There's a complaint filed back in August of '23 that never got heard in relation to the same thing. Carol Westlake said that the commission would talk about it. Mr. Hayes responded to an email saying the commission would talk about it. Billy Fields replied, said the commission would talk about it. It wasn't heard in August of '23. We've waited our turn, is my 2 cents.
All right. And Mr. Winters, you said you had something else you wanted to add?
Oh, once again, I have other complaints. I try to break them up in sections. I didn't want to overwhelm it with one long, hideous complaint, so that's why I did that. My goal here at the end of the day is to figure out why they are allowed to operate. That's it. That's my only goal.
All right.
In relation to that one complaint, this side note.
Thank you, Mr. Winters. Does staff have any recommendations here with respect to the deferral?
Mr. Chair, we would recommend deferral. I don't believe the information public record request was answered timely, so I do believe that the motion by the Old Town Trolley's attorney is valid, and we should defer.
Any further discussion by the commission?
Mr. Winters, you said you had a complaint in August? The same complaint?
Exact same complaint with proof, video, and everything documenting it. It's not from me, it's from a lady named, I can pull up her email real quick.
And we deferred that?
It wasn't heard, it never made the agenda. Even though Ms. Westlake, Mr. Hayes, no offense, Mr. Hayes, mentioned in an email they would find out more about it. I think Mr. Hayes' email said, if you're concerned, come to a meeting. Ms. Westlake said she would check to see how it gets on the agenda. And that, Mr. Billy Fields was copied on that, and I have copies of those emails.
Was a consumer complaint actually
It was a
filed?
consumer filed complaint sent to all TLC members, Hub Nashville, director, I have copies of all of it. Her name was Grace, I think,
The one that had the video that had the timestamp that she got on it,
on her watch.
at like on Church Avenue?
She rode the whole tour from 2nd and Broadway all the way around Nashville and from 4 till 5:30.
That video wasn't shown here? That was shown here.
It never made it here. She sent 3 follow-up emails saying, can it be heard? Nobody ever heard it. Which I have copies of. That was prior to Ricky's time.
Forgive my memory. So then, did she send a link to us? Because I do remember seeing a video.
She sent multiple videos. She did her watch timing and multiple
A
times.
woman getting on a bus, making a complaint.
Yes. August of 23. And follow-up
And it went
emails,
to
3 of them in
Hub.
September.
It went to Hub. It should have been followed up.
Yes. I'm not pointing fingers. I'm simply saying that this is not something new. This has been going on for close to 2 years now.
I'll make a motion. Has Metro Legal had an opportunity or enough time to review these complaints, or do you need additional time as well?
We would also recommend the deferral.
I was noting that the complaints were filed April 1st. Mr. Rosenblatt's and Mr. Winters, if I'm reading correctly, were filed April 1st, and I understand the other one was filed April 3rd of this year.
The 3rd was the cutoff, I think.
I make a motion that we defer Mr. Rosenblatt, Mr. Lyon, and Mr. Winters' multiple complaints to, the May meeting? Is that going to be okay?
Probably would make it June.
Staff recommend June. That is going to be.
All right, I'll go with staff's recommendation that they be deferred till June.
Can I
Give
make one?
everybody adequate time to be prepared for a full hearing on this matter. And it's going to be lengthy because we've got multiple complaints here, so.
Can I make one comment, or is it inappropriate?
Mr. Winters, you can go ahead.
Can the commission at this time, and this is a tough one, can the commission at this time make sure they stop operating? It's a violation of the rules. I've seen no rules, I've seen no maps, I've seen no guidance other than one comment saying they were approved special routes. I've never seen a route, you guys have never seen a route. The commission in its own meeting said it will decide all rules, all modifications of the rules, that the NDOT director, TLC director, attorneys don't have the authority to modify rules. I would think as the commission, if a special route really is applicable currently, then we should all be able to run it until the meeting be heard. If they can run from 4 to 6, give us the route, we'll run it. The attorney just said rules apply to everybody. So if we're gonna adjourn this till June, let me run from 4 to 6 on June on whatever route they're supposedly running. If not, ask them to stop running. I think that's fair. That's a big ask, but I think it's fair.
Mr. Winters, I'm not aware of any special rule
Well, it was
allowing
mentioned by the NDOT director last
anyone
meeting.
to operate between 4 and 6. So I would follow our existing rules that are in black and white.
Well, here's my question. The NDOT director said at our last meeting, they were giving a special permission to run a special route approved by the prior TLC director.
I don't have anything on behalf of the commission to say right now. So, Mr. Winters, I would follow the rules of the TLC that are in black and white.
And does apply to everyone,
Yes.
including Old Town.
Those apply to everybody.
So because you've seen no special route, they cannot operate today from 4 to 6. And every day after until this agenda is actually heard.
Mr. Winters, we're going to have to address the rest of your issues in June.
I understand. Just looking for fairness, not special treatment.
All right, so the next item on the agenda is,
We got to vote
Second
on
the
it.
motion.
I made a motion to defer.
do we have a second?
Second.
All those in favor?
Aye.
Motion passes. Next item on the agenda is under consent items.
Actually, I'm sorry, are we hearing my other complaints that are not Old Town Trolley related?
We are not hearing any other complaints.
So all complaints got pushed?
Yes.
Not just Old Town Trolley?
That was my motion.
Okay,
I mentioned multiple complaints by you. Okay.
We have a number of consent items. First is under general wrecker and towing services. We've got new company applications, Anytime Towing and Recovery and King's Towing.
Two new companies, there's no, they're not staff recommends that they be approved.
You got room for more towing companies?
Yes, sir.
All right, I make a motion that we
We need
approve.
more towing companies.
Okay, I make a motion, we approve the applications of Anytime Towing and Recovery and King's Towing.
Is there a second?
Second that motion.
All those in favor?
Aye.
Motion passes. Next item under the consent agenda is under Other Passenger Vehicle for Hire. We've got several new company applications. Mr. Rooker, are these all in order?
Yes, yes, sir, all in order, 11 new companies, all paperwork in order, we recommend approval.
I've got a question. I know we do this a lot, and they're mostly for one-off. Are any of these large companies that have got 10 units, 3 buses? Do we even, when we approve these Uber Blacks mostly, is what they are?
They're Uber Blacks, yes, sir.
Okay.
They're all Uber Blacks.
I'm with Commissioner Carr in that I'm just amazed at how many OPVHs we approve every time.
We actually had 125.
Oh, there's how many there are?
Yeah, we actually had 125 companies that did not renew.
Oh, interesting.
Okay.
So they're your stats on the sheet.
Well, based on Mr. Rooker's recommendation, I would make a motion to approve all 11 OPVH new company applications.
Second that motion.
All those in favor?
Aye.
Motion passes. Next, we have an existing company's reapplication after failing to timely renew by Allure Transportation LLC, Blue Nile Limo, Light Shine Transportation, and Mafi Limo Service.
Yes, sir. All companies paperwork is fine. They missed their renewal date, and they have to reapply, so it has to come before commission for approval.
Okay. Rather play devil's advocate here again. These companies, these renewal dates were missed by a few days,
A few days.
months, a few
No,
days.
the deadline is the 31st
Okay.
of March, so they were in there probably the first week of April.
I'll make a motion to approve the renewal of application for these existing companies, Allure Transportation, Blue Nile Limo, Light Shine Transportation, and Mafi Limo Services.
Second?
All those in favor?
Aye.
Motion passes. Next, we've been asked to request to add a partner to Other Passenger Vehicle for Hire company, Mini Vegas Limo.
So they're just adding another partner. The paperwork's in order, staff recommends approval.
Make a motion to approve Mini Vegas Limo, adding partner, adding the partner listed,
I'll second that.
Abdallah, I don't mess that name up so bad.
Avita. Avita.
Avita.
Yes, sir.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. We also have several requests to change addresses for Other Passenger Vehicle for Hire companies. Mr. Rooker, are all these in order?
Yes, all companies are in order. They're just basically changing an address of the company. They're all in order. Applications are ready to go. Staff recommends approval.
I'll make a motion to approve. Change of address for OPVH of AZ and B Affordable Limo. I'm assuming this is, I'm not gonna assume, BLK LN LLC, Getaway Car, Nori Car, TN Limo, Bella Limo, and Santa Limo.
Second.
All those in favor?
Aye.
Motion passes. Before we get to the application reviews, Mr. Rooker, do we have any other business?
No, sir. No, Chair. No other business at this time.
Yes, Mr. Rogers.
I promised I would ask what was the current status of an RFP for dock bike share.
The dock share RFP, actually, staff gave me a preview of the scope of service. It's now being circulated internally to all departments that are involved in this. We're expecting answers back by the end of next Friday, and then we should have a set draft that we can consider ready to move on to procurement. And then procurement will add their stuff to it, and it should go out into the marketplace.
Well, we have to approve it first.
You do not have to approve the RFP, you approve the contract.
We approved the RFP last time. I'm pretty sure
Teresa?
legal's not listening.
Teresa, does the TLC approve the RFP, or do they approve the contract for a dockless?
They definitely approved the contract, and I think the last time they may have approved the RFP as
We
well.
did, yes, we did.
Okay.
Because I tried to change.
I have to check, I don't remember.
Could you check for me and let me know? If we have to bring the RFP before the TLC, we will. That was not my understanding, but I have no problem with it.
Anything else, Mr. Rogers?
No, I fulfilled my responsibility.
Okay, at this point, we're going to move toward several application reviews for individuals. At this time, I need to make a statement notifying Metro Nashville Network that our meeting coverage needs to end because this section of the meeting will consider confidential and protected criminal history background information of our driver applicants, and so we're going to stop recording at this point. Thank you.
Do we have to clear the room?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.